what I do. Oh, recording in progress.
Sorry, yes.
Um,
Yeah, it's
that's
being
right.
recorded.
And how did I get here? I did a law degree in Australia. I then undertook a master's in Seoul in South Korea. I worked in an international arbitration practice group there, which was called Bay, Kim and Lee. I worked there for about 2 years. I then came back to Australia, was a lawyer for about 2 years. And then I went and did a PhD under Professor Schultz. While I was over there, I did a bit of work as well, a bit of arbitration stuff. And then I came back here, sat at the bar, and became a barrister. We have a split profession in Australia, which is not unlike England. For those who are familiar with England, we have solicitors who do what they do, and I don't know what they do. And they brief barristers, and that's me. So we're primarily concerned with the advocacy aspect of cases and the strategy aspect of cases, ultimately trying to persuade a judge or an arbitrator that you should get the relief you seek. I do all commercial law. I've never in my life done a criminal matter. That's probably a good thing. But ultimately, there's that whole aspect of Australian law, just like every other country where you have sort of a criminal aspect and a commercial aspect. I'm solely in the commercial aspect, although admitted to practice in both, but don't hold myself out in that way. Can you become a lawyer or barrister in Australia? Certainly. If you are a Swiss lawyer or you are admitted on the continent, you would have to take a number of courses, which would essentially be bridging courses, but you would not have to start at zero. So I'm not sure how long a sort of a law degree in Switzerland is, but presumably you take many cases over many years. A lot of those cases would be recognized as being of some relevance, but you would have to take and people are given leeway for the experience they have if they're practitioners overseas. But ultimately, you've got to sit certain cases which we consider to be particularly important. So ethics, constitutional law, contract law. In fact, largely a lot of the things you're learning in this course by the looks of the syllabus, although you would need to learn them too. Contract law would be its own sort of 12-week course, and constitutional law would be its own 12-week course, and that sort of thing. But it's not unheard of, and it happens all the time. If you are admitted in England, then it's a very short hop, skip, and a jump over the pond. You'd probably have to take 2 courses, and that's because our laws are basically the same. It's commonly the case that Australian lawyers just go and work in England. They do a small bridging course that takes sort of like 6 weeks, and then they're admitted to practice, and vice versa. And often it's pretty easy for us to sit the American bar because, like, you would take the New York bar because it's largely the same as well. Provided you've got a law degree, provided you've studied, you can probably do that because it's just not that foreign. But on the assumption that most of you are probably Swiss trained, it is unfortunately further away, but I know a lot of Swiss lawyers who ultimately become lawyers in London, for example, and if you had the requisite practical training in London, you would easily be able to just bring it over here and do that. And sort of about a third of the profession here is probably English. And sort of in London, I think a third of the young junior solicitors are probably Australian. So it's a common jump to make that jump across the pond. So I'm not sure if that answers your question, but on the assumption that most of you are Swiss lawyers, it's further, but it would be not dissimilar to trying to get admitted in England, I think, if that makes sense.
Perfect. Thank you so much. I think that's very helpful and makes me enthusiastic about possibly going to Australia. Anyway,
Yeah.
thank you. I think that's very clear.
I would say as a mode of practice, I mean, and we'll talk about this because the law is just not dissimilar in the slightest, but as a place to live, dreary old London or Australia, I know which one I would pick. I mean, it's a part of the reason Thomas would say, I wish you went into academics, but I don't think I could do another European winter, was the fact of the matter.
Fair enough.
But anyway, look, what Professor Schultz asked me to talk about was what he called the specificities of Australian law. I'm looking at the syllabus. And I take the good professor to mean essentially what makes Australian law special or what makes it unique. Now, if I look at this syllabus, just bring it up now. Sorry. So I'm looking at this syllabus, and I'd probably say I've got good news for all of you, because I can see that the focus of the course has largely been on English and American law. And so why do I say that's good news? Well, if I had to describe Australian law to a civil lawyer, and a civil lawyer who knew or had some knowledge about English and American law, I'd probably say it this way. I'd say Australian law is basically English law with some American law thrown in for good measure. We have a real confluence of Australian and American law, but the true foundation of Australian law is English law. And that's why you have these people moving back and forth between England and Australia, because it's really very similar. So everything you've learnt about, in a sense, about contract law, tort, or equity are largely the same in Australia. And that's because Australia was established as a colony of the British Empire. So even today we have a constitutional monarch. So King Charles is our head of state, go us. At the same time, however, Australia is a federation of states. And so, well, we're a federation of states and territories. And we have this parliamentary system, which we call the Westminster system, which takes elements of the Westminster system in England and the US Washington system. And with that influence of the US Washington system comes this influence of American law and the American law common law tradition, and also this confluence of American and English law, which ultimately turns into something that looks like Australian law. Now, if I was to sort of sit here and tell you for the next 90 minutes about Australian contract law or equity, you'd probably say to me that Professor Schultz has already taught you about it. So what I thought I would do, or at least I hope might be a bit more interesting, is if I briefly set out the development of Australian law before touching on some of what I would say are the differences or the similarities and differences in modern Australian jurisprudence. And I can do that, I think, pretty easily because, as you know, Australia is a pretty young country, so we haven't really been around for that long. We're only federated in 1901, so we're about 124 years old. Look, in my view, there's really two things which I think make Australian law or the Australian legal system special, or perhaps distinguish it from other jurisdictions, particularly England. The first is what I would say is our willingness to borrow good ideas to hard problems. And it might be, again, because we're this relatively young nation, or it might be because we've got a mixed history of that sort of English, Americano sort of system. But we're really not shy to draw on the jurisprudence of other common law jurisdictions. And there's this willingness and enthusiasm to cite, rely on, and expand upon other cases in Australian jurisprudence. So it's not uncommon where there's a lacuna in the law for a judge to ask me in court, says, well, if you don't have any Australian case on it, is there some foreign authority on this? Is there anything in England? Is there anything in the US? Is there anything in Canada? And if I say, well, I don't know, Your Honour, I might get a bit of a blank stare, because I really see it as part of my job to know the answer to that question. And the courts expect it. And so, particularly in the higher courts, so in the High Court of Australia, which is the court that sits at the apex of our judicial hierarchy, and also the state courts of appeal, barristers are really expected, as a matter of practice, to draw to the court's attention cases in other jurisdictions, particularly where there's a lacuna in the law and you're saying to the court, look, this hasn't come up before, and this is the answer. And the court will say, well, has anyone else looked at this problem before? Is there any authority in any other common law jurisdiction which we can draw on? So again, I see it as part of my job, and it's a matter, it might be a part of my job to do it and what the court expects, but I think it's also a matter of proper advocacy, because ultimately, when I tell the court the answer is this, it's maybe worth something, but when I can say, oh, well, the US Supreme Court has actually looked at this exact same issue, and the majority found this, or all of them in unanimity found that this was the answer. And then I know that the court here in Australia is going to have to grapple with that and sort of say, oh, we're going to have to depart from, we're going to have to say, no, the US Supreme Court, all of those justices were wrong. So it's a good element of there's a good sort of advocacy point in it, but at the same time, it's what's expected of us as advocates in and of itself. But because of this, I tend to read a lot of English cases, and I read quite a few American ones as well. So every time there's a UK Supreme Court case, I will read that. Most of the time when there's a US Supreme Court case that's in my area, I will read it, although less so. But at least my impression when I'm reading these cases is that I don't think this same willingness and this same enthusiasm to look beyond national borders is shared by my UK and US friends. So, and I'm not saying that that doesn't happen, because it clearly does. And if you look in the reports and you look at US Supreme Court cases, you look at UK Supreme Court cases, and I'll touch on one later, you do see that they refer to Australian decisions, for example, in the English reports. But it's nowhere near, in my view, the same extent. And I think that's because, at least England for the main part, thinks of itself as the source of all common law. And, you know, it was the first one. It's the place where all the common law went out into the world. And so why do you need to look at, you know, sort of branches of the tree when you're already at the trunk? And perhaps Americans, I mean, I say this jokingly and I hope there's no Americans, but perhaps Americans think of themselves as sort of the center of the world. So again, why do you need to look outside your own national borders? I mean, I say it jokingly in the sense, I know they don't think they're the center of the world, but I do think that they have a nationalistic view of the way in which they look at their laws. They don't look at them as going, well, let's see what everyone else is doing and see if we should adopt that. They say, well, we can do this ourselves. We got good courts, we got good judges, and they do. But it's not to say that there's nothing else out there that can't help them. The second unique aspect of Australian law, which I thought might be of interest to civil lawyers, is what we call in Australia the law of native title. And, oh, sorry.
So can I very briefly draw? There's a question in the chat. I can read it out to you. No, I knew it's my job to read out. Do Australian lawyers also look into civil law jurisdictions for ideas? Because there's a strong, anyway, yeah.
We do and we don't. We do on issues that arise from common civil common law issues, but less so in respect of other issues. So, for example, I wouldn't go searching the French Court de Cassation for some equitable principles in the hope that that might assist me when I'm talking about restitution here in Australia. But, you know, there are all manner of international agreements. There are conventions on the sale of goods. There are commercial agreements relating to flights and international flights. There's, of course, international arbitration legislation, which goes down to a national level, but comes from model rules, and those model rules are applied in other countries. And there's in a sense, it's a good practice where you don't need to diverge from one another to have some sort of conformity in circumstances where you have this sort of large international interrelated world. So, you know, it's not unheard of, for example, the Australian High Court to say, oh, let's look what the French say about these model rules or these same rules that we have adopted in our legislation. But because the concepts at common law, I think, are so different, and I say this different from an origin point of view, like principles of equity, principles of common law, how all these rules developed, it's, you know, you tend not to see it in that context, but you do see it in the context of where you have international agreements and they're saying, oh, how should we interpret this? And you find it all the time, references to French courts or Swiss courts or whatever it may be. Does that answer your question? I have two bubbles, but I'm unable to actually see them for some reason. So I don't know if there's two questions. But...
No, thanks. The other question was a question about recording the class. It's, I think, as far as I'm concerned, I think it perfectly answers the question. Yeah, thank you.
The second part, and we'll come back to talk about what I call the confluence of, I guess, English and American law in Australia and other jurisdictions, but it's primarily common law jurisdictions which we looked at. And it's jurisdictions such as Canada, jurisdictions such as New Zealand, Hong Kong, when Hong Kong was, when there was a much greater English influence in Hong Kong, let's put it that way. And obviously England and America are the two big players. The second aspect of Australian law, which I think is unique and is of some interest, I think, or maybe of some interest to civil lawyers, is this idea of native title. And I think it's unique to Australia. And as far as I'm aware, I don't think it exists in other countries, although it may be that other countries deal with it in different ways, for example, at the legislative level. But look, we'll come to discuss it in more detail, but essentially, and I don't want to have a lecture on sort of 17th and 18th century international law, but Australia was settled by the British in the late 1700s. And essentially what happened is they declared the land what we call terra nullius. And terra nullius essentially is Latin for, it means nobody's land. And the result of declaring land terra nullius essentially is that the British could apply their laws on a blank slate. And perhaps most importantly for the British was this conception of property rights. You could apply English property rights. It's the idea that if you own land, you have an indefeasible title, which means your title defeats everybody else's interests. And the idea that you have exclusive possession. If someone walks onto your land, you can have them removed. You can remove them yourself, or you can have them removed. And this is your little patch of land that nobody else has an interest in. And that's a very English conception. And when we talk about rights, particularly in the common law, property rights, proprietary rights are king of the rights. They are the rights that, that's the rights at the top of the pyramid. And that's a very strong, conception in the English common law tradition, this idea of property rights and how property rights interact. And they haven't changed for a very, very long time. But in the late 1990s, the High Court Australia overturned this doctrine of terra nullius and recognised that it's essentially what we call a legal fiction. And so it recognised that prior to British settlement, there was in fact very sophisticated legal systems adopted by Indigenous populations. But in Australia, and unlike in other jurisdictions, I think, the courts have recognised that there's in fact perhaps some rights which still remain, which Indigenous people can claim, and those somehow have to coexist with English conceptions of property rights. And the courts have for the last sort of 20 years been sort of meddling with this idea of, oh, okay, you have exclusive possession, but there's also these things called native title rights, because we have to recognise that we essentially took land off people who actually had a system of government. And then how do we make those two things work together? And I think, at least in my view, it's sort of changing the way in which Australian lawyers conceptualize property rights and property law. And that's different to the way, it's departing from the way in which the English might consider that, because the English don't have to confront this idea of, well, sort of taking someone's land relatively recently in history and supplanting it with, your own laws, and then coming back and saying, oh, perhaps we shouldn't have done that. How do we fix this? But having gone too far, you can't rip out the whole system. So what do you do? And this is a real live debate, both politically, but also at the courts as well. Like, how do you mold ancient property rights or rights that have been around for hundreds of years? And how do you change those? It's like turning around the Titanic, because these are so embedded in what we consider to be rights. And such important rights. So what I thought I would do, that's just a small introduction, but what I thought I would do is start at a high level about the development of modern Australian law. And as I said before, I don't want to give a lecture on international law. Thomas can certainly do that. Professor Schultz can certainly do that. He's certainly better placed than me to do so. But essentially, during British colonial times, if you wanted to establish a new colony, you could essentially do it by force. So you could conquer by force. You could conquer by agreement, like reaching cede by agreement, essentially. Or you could settle it by what they call a right of occupation. And it's this third sort of option, which is the easiest one if you're a colonizer, which is to declare land terra nullius. You say no one lives here. And if land's terra nullius, you don't need to recognize prior laws. You can simply apply English law on a blank slate, right? But of course, when the British arrived, in fact, there was, quite a large Indigenous population which had its own laws, but those were not laws that were recognised at the time as being sort of the laws of sort of civilised nations. And so what do you do if you land on the sandy shores of Australia in the 1770s? You don't want to go back to dreary old London. What do? You for want of a better word, you stretch this concept of terra nullius and you say, well, maybe terra nullius includes not only uninhibited lands, but maybe it also includes uncultivated lands and lands with no established governments. And maybe it goes that far. And you go, oh, well, the Aboriginal people, they're not farming, they're not engaging in modern agricultural practices, they don't have a centralized government. This is really terra nullius. And so once you find that land is terra nullius, you can then say, well, let's just apply English laws because we've essentially discovered it. And so in about the late 1700s, the first British settlers started to arrive in Australia. And I think there's this common misconception, at least when I used to live in, I lived in Paris for 4 years. There was this misconception that Australians were some sort of like descendants of like murderers and rapists and all these horrible people because they'd all been sent to this penal colony. And to an extent, that's true. And if you look at the reports, you can see these unsavory characters just being banished to the other side of the world where they just don't want to deal with them or have them in England anymore. But really, the policy in England at the time was to relieve overpopulated prisons. And it came to a point where in the late 1700s, the prisons in England were just so jam-packed that people were committing crimes and they just had nowhere to put them in the prisons. And they were committing crimes like stealing a loaf of bread or, stealing some potatoes or something like that. And the judge would be like, all right, we got nowhere to put you. You're going to Australia. That's where I'm sending you. And so I don't want you to think that we're all descendants of murderers or whatever, because in fact, some of our forefathers just wanted to eat some bread and it's really not that bad. And you can't, in fact, probably start a full colony on sort of just by sending all the murderers there. But, both unsavory characters and slightly less unsavory characters were sort of sent. But there was this idea when you move to another country in the sort of late 1700s, there was this theory that you would take English law as your birthright. And it sounds incredibly pompous to say now, like, oh, I just take English law as my birthright. Or if I just sort of fly to France and I'm like, I take Australian law as my birthright, you'd be laughed at. But at the time, that was the theory. And so the law moved with these people to Australia and into the Australian colony. And in about the 1800s, there was an act, the Australian Court Act, which was passed, which effectively gave effect to this court system in Australia that mirrored what was at the time the English system. And importantly, those courts applied English law in Australia. So there was no conception that they were applying Australian law in Australia. They were applying English law in Australia because Australia was just a colony, just a branch of essentially the British Empire. As horrible as it sort of sounds, by declaring Australia terra nullius, by refusing to recognise Indigenous Australians as people, English law was effectively applied just blank slate, as if no law ever existed before, if no one was there before existed. And this is different to other common law countries that are around Australia. So it's a little bit off topic, but we obviously have a very strong connection with New Zealand. We form a common market for sometimes, we form a common army for some things. We share each other's jurisprudence. They basically steal all of our legislation, willingly steal all of our legislation. We are basically the same people, they just have funny accents. But unlike Australia, in New Zealand, of course, when the British arrived in New Zealand, they ultimately weren't able to do the same thing that they did here. And they had to reach agreement with the Maori, which were the Indigenous New Zealanders. And so they obviously took that second option. Well, that was obviously that second option where the Maoris ceded. Well, it's a bit controversial, but the Maoris ceded essentially to British rule. But in return, they got recognition for a lot of their rights. And that's how New Zealand was founded. So when you go to New Zealand, they have again this other completely different system, which is a mix of English law, but also traditional Maori law and all sorts of things, which we just don't have in Australia, because in Australia, there was they just said, no, we're just not going to recognize anything here. We're just going to supplant English law on top. And that's that. Now, that takes you to sort of the early 1800s. And in the next 100 or so years, what happened was sort of six or seven colonies, I think it was 6 colonies, self-governing colonies emerged in Australia. And each of these colonies effectively modeled the British parliamentary system. So each had something that looked like the Westminster system, and each had courts that applied English law. And then it was not until 1901, so about 124 years ago, I think I said, these colonies came together as a federation and formed what we call the Commonwealth of Australia. Now, of course, prior to this time, for like American history buffs, obviously the Americans were having their own sort of issues with the British a little bit earlier, and obviously they declared independence from the British. And so there's a lot of discussion in 1901, around that time, or 1900, about, well, what would the Australian Federation look like? What would our nation look like? And ultimately, perhaps to the dismay of the British, it looked something like a halfway house, and which is what we call that Westminster system. So it's got these elements of English government, which is the Westminster system, and it's got these elements of the US Washington system. And so we have a thing called the Senate, which looks a lot like their Congress, which is different to England. But then we also have a House of Representatives, and we have a Prime Minister and no president. And so it's a mix of the two. And it's really at this time, at least in my view, this is sort of setting the seed for, well, we're not, just because the British do it this way, we're not Britain, although we're subject to British rule, we're a British colony, but we're not going to do as the British do just because that's the way the British do. We're going to have a bit of a think about it, and then we're going to move on and see what we can do. And so we adopt parts of, what we thought was a good part in America, and we adopted parts of the English tradition, which we thought was good as well. But we weren't so nationalistic or so deeply rooted in tradition, perhaps like the English would be, to just say, no, this is the way it's always been done. This is the way we're going to do it. And that, I think, spurs on 100 years later, this idea, well, we'll just take cases from anywhere. And, if they're good ideas to hard problems, we'll take them. It's interesting, though, it wasn't until the late 1970s that if you're unhappy with the decision of the High Court of Australia, which is the highest court in Australia, you could travel to London and you could appeal that decision to the Privy Council. So in fact, the Privy Council was the last or highest court in the land, although it was in London. And so in the early 90s and even up to the 1950s, you see judges in Australia and England completely criticising this idea that Australia should be free to sort of develop its own Australian common law or its own Australian laws. Rather, the idea was that, well, you have the common law of England, and that's the common law that should be applied in Australia. And why would it be different? Or why would it be any other way? And of course, we're still a constitutional monarch. So when laws are passed in Parliament, they ultimately get stamped, by King Charles, I guess. Although he doesn't turn anything around. But that's just as a matter of practice. So what you did, and it's quite funny, and you read these reports from back in the day, in sort of prior to 1970, and particularly in the 50s, if you wanted to challenge a decision of the High Court, you had to lodge your appeal to the Privy Council in London. Then you'd have to get on a boat, which would take about 3 or 4 weeks to get to London. Then you'd have to argue your case in front of the Privy Council, and then you'd have to go home, which would take another 3 or 4 weeks to go home. Then the Privy Council would, of course, at the same time, on the boat, you're working up the case. So you've got to there's no computers, so you've got to take every book you own and, every law report that's ever made. And because you don't want to be on the boat and realize you're sort of missing like the seminal case that you need when you turn up in 3 weeks and you can't get it. So it's quite funny to think of it that way. But essentially the Privy Council would then make a decision, and it might uphold the High Court's decision or it might overturn it. But whatever the result, every court in Australia would be bound by that, including the High Court, which is the highest court in Australia. And that's only in the sort of 1965, and then it was completely abolished in sort of 1975-ish. And so, there's still people I practice with, like sort of quite old barristers who I work with, who sort of went to the Privy Council. And to me, it sounds like a mad thing because I wasn't born then. But, they, of course, were, and they were practicing, and they say, oh, yeah, by that time they were getting on planes, but they were sort of young whippersnapper barristers in front of the Privy Council from Australia. Ultimately, in the 1970s, the Australian legislature passed laws effectively ending all appeals to the Privy Council. And in doing so, they essentially confirmed the independence of the Australian courts and declared, the High Court is the highest court of the land. And unsurprisingly, it wasn't received super fondly by the British, but, you know, too bad, too sad, I say. So that's the way it goes. So where are we up to today? Ultimately, that sort of brings us to a period, I would say, what I would call modern Australian jurisprudence, which ranges from, I would say, about the 1980s until today. So you're looking at sort of probably about the 1970s or the 1980s onwards up to today. And since about the 1980s, the High Court of Australia has established this idea that you have a distinct Australian common law. So not English common law that applies in Australia, but you have this distinct Australian common law. And so that's a common, and the way in which it's put is, it's a common law which is historically rooted in the common law of England, but it's responsible to our own society, its conditions and circumstances. And it's influenced not only by English law, but also comparable decisions, right? And the courts call these comparable decisions, they say, oh, the courts from other great common law jurisdictions. And I mean, who are these other great common law jurisdictions, you might say? Well, the United States is the big one. And I would say probably 90% from the United States, if you take England out of the equation or the UK out of the equation. But Canada and New Zealand, which share a lot of similarities with Australia, are also the same. And Hong Kong as well, in days past, was, you know, also a dearth of precedent there that you could rely on, and you could draw the attention of Australian courts in support of your argument. And a lot of time that was the case because in England and in Australia, there's a constitutional age for when judges must step down, but there wasn't in Hong Kong. So what they would tend to do is they would be sort of told they have to step down here, 70, and then they go, well, I'm still okay, and they go to Hong Kong and they'd be put on these sort of courts as, you know, as a justice of the Hong Kong court. They'd be doing their best work when they're 85 until they go sort of senile or something like that. So, you know, it was an excellent jurisdiction. But of course, now with what's happened with China and Hong Kong, obviously you get this place where, well, you go there and the precedents are not, they no longer resemble the sorts of problems that you're facing here in Australia. And so they become less useful. And so you look elsewhere, and you look to Canada, you look to the US, you look to New Zealand. And in particular areas, for example, like human rights, you know, Canada sort of leads the way. And, you know, if you're in that space, you're always going to Canadian decisions. If you're dealing with administrative law review issues, again, that's, you know, people commonly citing Canadian cases. And a lot of time the Canadian cases are then accepted in Australia, and you're citing the Australian case, and the Australian case cites the Canadian case, and, you know, you go down a sort of inception of cases. But that's sort of the way in which it works. At least I thought it might be useful, at least to talk about my practice. And there's at least two areas where I think probably in the last month, I have had to get into the weeds of sort of comparative jurisdictional review of decisions from other jurisdictions. The first one is in the context of construing the scope of contractual obligations of good faith. Now, I saw you've sort of dealt with sources, I think it's sessions 4 to 6, it looks like in the syllabus. You're dealing with contract law primarily before you move on to tort. But if you I'm not sure whether you touched on questions of contractual obligations of good faith, but in America, you know, it's sort of widely accepted that where parties enter into contracts, they owe this obligation to act in good faith with one another. And then it's through this prism of good faith that all other contractual obligations are construed. But this concept of an obligation of good faith has traditionally been foreign to Australian and English law, where we have the idea of caveat emptor, so, you know, buyer beware, everyone's out for themselves, you make a deal, and that's the deal, it's in the 4 corners of the contract, and it's not in there, then I don't owe you anything else. It's also this idea of good faith, or contractual obligation of good faith, is kind of the thing that would scare common lawyers normally, so English lawyers and Australian lawyers. It's kind of this nebulous concept which of good faith, which nobody can really tell you what it means, but apparently it's going to dictate everything I do, and the way in which I can exercise my own obligations under a contract. And if I sound a bit suspicious, I am, because it's my clients alleged, in this case, my clients alleged to have breached this sort of implied obligation of good faith, and which just sounds like rubbish to me. But you know, it's making its way though into Australian law, and you can see it. So I've had to go deep into this and sort of look at it. But if I look at the Court of Appeal level, and it hasn't been decided at the High Court level, but if I look at the Court of Appeal level, I can see there's this idea that perhaps, you know, and there's nothing real, but you can see the seed of it coming from America, where they say, oh, we don't have that concept in Australian law, but then they'll spend 4 pages talking about how it might be a good idea, and look what the Americans are doing, and here's the cases that they rely on. And then you get these judges who say, well, it's not, I don't need to decide that for this case, but perhaps this would be a sort of a good idea for particular kinds of contracts, like consumer contracts or insurance contracts, or contracts where an obligation of good faith might be useful to sort of lubricate the obligations and duties and that parties have. But it's traditionally been foreign to Australian and English law. And so similarly, parties sometimes put these obligations in expressly. They might say expressly, you have an obligation of good faith to me, and I have an obligation of good faith to you. What I'm dealing with in the case, I'm dealing with this concept of an implied obligation of good faith. And can you imply it? And then if you can imply it, what's the scope of the obligation? And how do you determine what the scope of the obligation is? But when you go to these Australian cases, they say, well, this is kind of foreign to us, but why don't we look at what the Americans are doing? Because there's thousands of cases on good faith. They've been applied in every factual matrix one can dream up of. So what do? You look at the American cases, you see if your factual matrices come up, you have a look at the reasoning, you have a think about whether or not you think that's persuasive or not, whether that fits within, you know, if you were to sort of rely on the reasoning, whether it fits within our construction of the law, like the English Anglo-Australian construction of the law. And then you see if you can bring it in. But you can see these seeds of it coming in. And I think if I gave this lecture in, say, 5 or 6 years, I almost have no doubt that courts will start finding that there's an obligation of good faith. And it'll eventually get to the point where someone just says, I think there is an obligation of good faith at common law, and it can be implied in these circumstances. And I think all these American cases are right in the way they construe it. And this is the scope of it. And, you know, it sort of will come in. And that's how it comes in. So that's a sort of example of the seeds of something coming in, but it hasn't quite formed. But you can see it happening in real time in practice. And I can almost guarantee in sort of a decade, 6, 7 years, you know, there'll be a doctrine of an implied duty of good faith. And I don't know if it'll be the same scope as the American one, but I can see it because it serves a purpose. You know, when people enter into agreement with each other, perhaps they shouldn't be stabbing each other in the back. Perhaps they should be acting in good faith and trying to get towards the common goal that they've agreed to. And so you can see why it might be useful and why courts might look at that and go, wait a minute, maybe this is in the commercial interests of parties to actually do. Another example, which I'm dealing with at the moment too, is the doctrine of penalties, which is a really interesting area. And I'm not sure if there is a civil law equivalent. I never sort of looked into it, but essentially, how do I explain it? Essentially, I could enter into contract with Professor Schultz and ask him to tutor me for, in Swiss law, for $100, you know, a session. But what I can't do, and that's a valid contract, there's nothing wrong with that. I want his services and I'm willing to pay $100 for it. There's an offer and acceptance and consideration, mutual promises, legal intention, etc. But what I can't do is sort of put a clause underneath that says, and if Professor Schultz does not turn up, he has to pay me $1,000. And so we call that a penalty. It's an obligation which seeks to reinforce by way of a penal nature a primary obligation. Now, the courts will say, well, that's contrary to public policy. They say, we're in the business of holding people to their bargains and compensating people for breaches of contract for their loss or damage. But we're not in the business of penalizing people. That's criminal law. And so they say, we don't enforce things like that. And you get into complex situations where what is and what is not a penalty, because when you are I do a lot of construction matters. And when you're late on a case, or when you're late on a project, every day that you're late, you might owe something called liquidated damages. And that's an amount of money that you have to pay the principal for every day you're late. And then there's an argument about whether or not that's a penalty or whether it's a genuine pre-estimate of your damages that you will suffer and those sorts of things. So it's a really quite complex area, and it's, it has a lot of facets to it. But the interesting part is, or at least I find the interesting part, is that in England and traditionally in Australia, if a contractual term was a penalty, then it was held to be void ab initio at common law. So if you included the primary obligation, Thomas is to tutor me for $100, and the secondary one, he owes me $1,000 if he doesn't turn up, essentially the second one would be void ab initio, and you can't enforce it. And so the contract would remain, but the clause would be unenforceable. Now, there is this debate happening that has happened and is continuing to happen in both the UK and in Australia, where the High Court of Australia and the UK Supreme Court are getting increasingly agitated with one another about how this area of law should work. And so it used to be the case both in England and traditionally in Australia that we all accepted that a penalty clause was void ab initio. It just didn't apply. If it was found to be a penalty, it didn't apply. And that's sort of always what you were looking for. If you're a defendant, you would say, oh, well, the clause is a penalty. It's void. I'm out. I'm completely out. And the court would say, yeah, sure. But in 2012, sort of at the start of all of this, the High Court of Australia had cause to consider the doctrine of penalties, and they revisited essentially the underlying sort of background to it and how it had developed through sort of for hundreds of years and how it got to where it is, because it is such a complex doctrine. So they thought, well, we'll redo this whole thing and look at it. And they went to the sort of great lengths to look at its historical development. And ultimately they held it had equitable origins. And so I can see in the syllabus that you've had some discussions about contract law, and presumably I think I can see there's some about equity too, and equitable maxims. And of course, there's millions of equitable maxims, but the general principle of equity is that it can sometimes be a bit rough to hold people strictly to their legal rights. And sometimes you have to smooth out the edge of the contract because enforcing it according to its terms would be just too strict or would result in an unjust answer. And so equity sort of comes in various kinds of ways to assist in that process, and in other kinds of ways too. But by finding that the doctrine of penalties had equitable origins, the High Court said, well, if that's the case, then why would the clause be void? The clause should just be read down to the extent that it would be inequitable to enforce it. And so you get to this point where the court says, well, Thomas they've made an agreement for $100 for this tutoring. The second one is $1,000. We don't think that Jason's actual genuine pre-estimate of his loss as a result of Thomas's breach of contract is $1,000, but we're going to read it down to a reasonable sum, and he can get $200. And so the penalty is, they would say it's no longer a penalty. It's just a genuine pre-estimate of the damages I would suffer as a result of Thomas's breach. But equity sort of come to the rescue and saved the clause to some degree. And so then you go back to and that's a radical departure from the traditional way of thinking, was that you can't save any aspect of it. It's just void. Ab initio, it's gone. It's unenforceable. And so what happens is, okay, well, 2 years later, the UK Supreme Court has cause to revisit the doctrine as well. And, unsurprisingly, what do you see? Well, you see the barrister in that case draw the UK Supreme Court's attention to the Australian High Court's decision, saying, hey guys, it's time to depart from, the traditional view of the doctrine of penalties. It shouldn't be void, it has equitable origins. This is how it should be done. And essentially the UK Supreme Court said, no, the Australian High Court got it wrong. And it's a radical departure from our previous understanding of the law. And you can't just depart from the law like that. And they refused to follow it. And so they upheld this idea that it's void. And then the next year, so 2016, the High Court in Australia comes back again to revisit the doctrine of penalties in a different case. Unsurprisingly, the UK Supreme Court's criticism of its prior decision is raised, and then the court has to sort of figure out what to do. And what do they say about that? I'll read it out because it's, I think it's telling of exactly where Australian jurisprudence is today. I'll just finish this quote and then we'll have a short break. So the Chief Justice of the Australian High Court said, in respect of the UK Supreme Court's criticism of their prior decision, he said, emphatic disagreement between our jurisdictions in relation to the common law and equitable doctrines, while infrequent, is not novel. The countries of the common law world have a shared heritage which they owe to the unwritten law of the United Kingdom. That shared heritage offers the undoubted advantage but does not import the necessity of development proceeding on similar lines. And he says, the common law in Australia is the common law of Australia. And then he says, differences have emerged from time to time between the common law of Australia and that of the United Kingdom in a number of areas. Those differences have not heralded the coming of winters of mutual exceptionalism. All of the common law jurisdictions are rich sources of comparative law whose traditions are worthy of the highest respect, particularly those of the United Kingdom as the first source. No doubt in a global economy, convergence, particularly in commercial law, is preferable to divergence, even if harmonization is beyond reach. So in short, he said, we do what we want. We're not going to follow, we do exactly what we want. We're not going to follow you just because that's the way it's always been done. We're going to adopt what we think is the right answer to hard problems. But, at the same time, showing a mutual respect for the tradition or the Anglo tradition, that our law is deeply rooted in the English tradition. It's deeply rooted in English law. And so, of course, UK Supreme Court decisions are highly persuasive in Australia, but there may ultimately be a better answer to the same problem in another common law jurisdiction or another, there's nothing to preclude you from going to a civil law jurisdiction too. It's just unlikely you're going to find it there. But there may be a better answer to the same problem in another common law jurisdiction. And we are seeing, I think, increasingly, particularly in practice, this increasing confluence of law from other jurisdictions. And that, I think, is a sort of unique part of Australian law. I think we should take a break for 10, 15 minutes, and then I'll just come back. I think I have about 15 minutes, so everyone can go home early.
Perfect. Thank you so much. Just on this point, so the Australian High Court followed its own precedents, didn't stuck to its own interpretation of penalty clauses, right?
Yeah. So in a sense, it revisited what it said in the prior case in light of the criticism that was raised by the UK Supreme Court. But ultimately it followed, it continued the exact way that it had prior to. So it considered that it still had the answer right. Mm-hmm. That was the better view. And so what you end up with is a divergence of English law and Australian law. Mm-hmm. And I think that's telling of sort of where Australia is at now. It's until the 1970s, this idea that it was English, in the early sort of 1900s, this idea that it was English law being applied in Australia. And that's what you were actually applying, English common law. And now you have this conception that we have a distinct common law of Australia that's applied in Australia. And it has its historical roots in England, but it's increasingly been shaped by, good answers in other countries. And we're not picky and we're not shy to throw away old answers for new answers if we know them to be better for our particular circumstances.
Was there, if I may ask, was there any reference in the latter case to American law, to US law on penalties?
Yes. Well, actually in the first case. So not in the latter case. In the first case,
okay.
They actually had a look at, and I can give you the citations if you like at some later point, but in the earlier case, they reviewed the sort of history of the doctrine, which primarily was a history of English law. And then they looked at what the US did, and they essentially followed the US. Yeah. As a method, they followed what the US is doing. But the way they got there was through a conception of that this principle has its origins in equity. Therefore, it can't possibly make something void. All it can sort of really do is read down the strictness of the provision to make it equitable.
So it's interesting. In a sense, the High Court said the UK court got it wrong in a sense that it's not consistent with the idea of equity. Instead of just saying, well, the English do whatever they want, but we just disagree. We think it's time for a different solution, without going into where this comes from.
Well, yes and no. In the first case, they said, we think the historical development of this doctrine has historical equitable elements and its origins in equity. And that has been misconstrued, and people have forgotten that, and they think it's a doctrine of the common law. The UK Supreme Court came back and said, no, you're misreading, the English cases. That's not the way it is. It's, there's nothing left in equity. It's a common law doctrine. In the latter case, essentially, rather than engaging in a sort of, they said, oh, we still think we're right, and we actually think that you are misreading our decision. But in any event, they said, what does it matter? He says, we have the common law. The common law in Australia is the common law of Australia. There's divergences. They will happen. What does it matter? This is our law, and this is what we're doing. And I think that's the sort of space we're at now.
Interesting. I find it interesting because three things must have played a role here: the sovereignty of Australia to say, well, we do whatever we want to do. We are an independent country and nation. To have compatible solutions between.
Well, even that is odd, isn't it? Because we're a constitutional monarch, so we're not a republic. Yeah,
fair enough.
You've got this overlay of we are kind of like England's little brother.
Yeah.
Then we're getting to a point where maybe the little brother's not growing taller than the big brother, but is growing equally as tall as the big brother, and says, "Wait a minute, I don't want to do it like this anymore." And so we tend to always do what the big brother says, but we're not scared to depart. But sorry, you were saying the first was sovereignty, which I partly agree with.
This relationship between the two countries, in a sense, do I follow the big brother or not? And the other is, should we have harmonized solutions? There's this big movement has been in existence for more than 20 years on the continents, in the European continent, to say we should aim for harmonized solutions as much as possible, UNIDROIT principles, and so on and so forth. And where they may have ended up saying, which would have been an interesting question, if two countries say, no, this is the right solution, which of the two gives in? But to say the purpose is we have to find a common solution. We have to find some kind of agreement. Is it your solution or is it mine? Or can we find some sort of negotiated middle way, as opposed to saying, this seems more important on the European continent than, well, we do whatever we want. I'm almost making a point to say, I'm an independent, as much as possible, independent country, and Big Brother is Big Brother's my dad.
I think there's a couple of things at play, though, in that last quote that I read out. And I was reading it out, and I haven't put it on the screen or anything, so it's maybe hard for you to recall. But the quote in and of itself, it says, well, it's our common law and we'll construe it how we want, and there's going to be divergences. But he says at the end of it, he sort of brings it back and he says, but no doubt in a global economy, convergence, particularly in commercial law, is preferable to divergence. So there's this idea, and that plays all through the common law, where the High Court has to think about when it does depart from decisions of other or the positions of other states and their courts, and says, well, is there an element at play where actually convergence or mutual agreement is going to be the same? And that's a lot of the time when you're looking at international, you're looking at local laws which have some international aspect, like the model laws which turn into arbitration statutes, for example. Commonly they're looking at all the other signatory countries and seeing what they're saying about it, because there is an element in that where they want to be consistent. They don't want to be an outlier causing sort of commercial harm where, people are sort of falling between two countries, And so there is that element at the same time, but there's sort of still this overriding idea that, well, this is what they think is the equitable answer in a sense, and that matters when it has origins of equity.
All right. Thank you so much. Yes, let's have a 15-minute break. Is that okay? For the break? Yeah. So we resume at shortly before past.
Sounds good.
Perfect. Thank you. See you then. The recording. So it's being recorded from now on. Again, take it away whenever you want. Oh,
so,
sorry.
So there's questions.
Exactly. There's questions. So do you see them?
Here we go. Yeah, I can see them now.
Okay. If you'd like to address them now, please.
Can everyone see them, or should I read them out?
Everyone should be able to see them. But I can.
Oh no, I've got it.
Okay.
As for the first question,
sorry. Perhaps it might make sense to read them out for the recording. Right now, everyone can read them, but in the recorded part, I'm not sure the chat will be included.
I'll leave that to you.
Okay. Good morning, good evening. Question number 1. Good morning, evening. Based on the example of the Australia-England's divergence over the doctrine of penalties, would you say that these differences are symptomatic of a broader trend? Is it safe to say that, in a few decades, Australian common law will develop a jurisprudence significantly different from that of England's also in other areas, and as a result will resemble English common law much less than it does today?
With this specific question as to Anglo-Australian, I would say no. I think there's very little risk that the divide will become so great that it will be like you're looking at a civil law system and a common law system or something like that. Our shared sort of history and culture, I think, is so significant, so significantly intertwined that the law just reacts to, the problems that it faces. And so for 97%, I'm going to say, of the law, it's the exact same. And there's just these bits around the ends where we come to different views. And most of the time, I think we come to the same view, not necessarily because we're following each other, but because we have the same way of thinking about it and the same legal tradition. And you tend to follow, I think, into the same pattern. Now, I remember having this conversation with, say, for example, Professor Schultz when he was my PhD supervisor. I looked at everything through a sort of case law theory view, which is you deduce principles by looking at the case law, and you go from there. And that's not necessarily how a civil law lawyer would do it, or perhaps not even close to how a civil law lawyer would do it. But I think there's a little risk that we will start thinking differently or radically differently, such that will then sort of result in our legal traditions sort of dividing. I mean, even if you were to look at the US versus England, and, of course, the history of America has a far significant greater backlash against the British over the years. I mean, their law looks not dissimilar. I couldn't put a figure on it, but I would have thought 70, 80% of it is still the same. And the differences primarily arise from the sort of meddling finger of the legislature. So, in Australia, there are differences to England, and they can be quite stark, but they arise from differences from the legislature. So, for example, when England was part of the EU and you had the introduction of sort of civil law concepts coming across, particularly in the conflict of laws area, coming across into England, those, we just weren't following those here because they're stemming from a completely different source. They're coming from what is essentially legislation and rules. Same here in Australia, different governments get in power, introduce different legislation. The courts are there to interpret the legislation and they're not there to make law. So, you end up with differences, even to very traditional concepts. And, native title is one of them. I see there's a question about native title in a moment, but I'll talk a little bit about native title, but that was first sort of recognized by the courts, and now there's legislation about it, and now you have a sort of what I think is a changed conception of property rights. And so, that arises from a combination of the courts and the legislature. But I don't think you're going to see I would happen to think even in 300 years, you're still going to have just an incredible confluence between the two. Unless the demographic changes significantly, I would have thought. And so obviously, there's this is a whole different area of sociology and law, but obviously if the makeup of your people becomes drastically different and the makeup of your people want different things, then of course you might start departing from them. And, changes in demographics and changes in what people want from their lawmakers obviously has a great effect on that. And so maybe that increasingly more things become legislated as opposed to developing naturally through the common law. And if that's the case, then I could see a significant divergence, but I doubt you're certainly not going to see one in a decade or two.
Awesome.
The other question.
I'll read it out. Aside from the concept of native title in property rights, to what extent do Aboriginal customs traditions influence Australian law? Sorry. Do courts take them into consideration? And if so, in what type of cases?
I wouldn't hold myself out as a native title expert per se, and I also wouldn't hold myself out as generally to be an expert in any other area except what I would call core commercial law. So it's not exactly my area, but besides native title, you do have courts do take into other considerations, but primarily in relation to there's all different kinds of legislation which regulates, I guess you would say, Aboriginal rights, duties and obligations and things like that in particular states. And there's in some places there are alternate court methodologies and things like that. For example, in the criminal law system, I think there's been a lot of studies on how, you can get better results from people who are Indigenous and who are offenders through different methods, as opposed to just sort of doing the sort of traditional send them to prison type thing. There's sort of community-based things that are more aligned with their customs. And I think often people in that space, I don't do any criminal law, but I'm aware of people in that space making submissions to the court that, there are better ways to sort of rehabilitate particular offenders, for example, before the court, and that might be more in line with their traditional customs, and that might ultimately enable a sort of better result. So I think the courts do take it into consideration in some limited cases, but to your extent, do they take it into consideration in all cases? Certainly not. It's something which is, to put it delicately, is always something which is like a difficult conversation, and how you deal with it as a legal system where everybody is under one rule of law, but you also have to recognize that there was a period of time in which certain people, certain class were completely dispossessed of their land under a legal fiction. So what can you do to remedy that in the present day? And so native title is the one that I'm primarily aware of because it can have commercial implications, but I think there is sort of scope for courts to take into consideration Aboriginal customs and traditions, particularly in criminal law and family law spaces, but generally not in commercial law. I can't really think of a scenario in which that would be the case. Unless you have sort of the only time in which I can think in a commercial context in which it might be considered is where you have sort of like two Aboriginal parties who make a commercial deal, and there is a question about the proper construction of the contract, and that might involve this idea that you have to have reference to traditional customs and traditions. But that's no different to the way in which normal sort of rules of construction work, which is, well, I knew I was dealing with a Swiss professor, and he knew he was dealing with an Australian barrister, and that was known to both the parties, and there's particular customs at play, and so certain words might mean certain things, and the courts would consider that anyway. but you might consider them in that context, in a commercial context.
Okay, assuming there are no other questions for the time being, I think let's just resume with the lecture, if that's okay with you, Jason.
Sure. I wasn't proposing to say an awful lot on this. Again, I don't hold myself out I don't practice in the area of native title. The cases I've been involved in where there's native title elements, we normally bring in a specialist barrister to deal with the native title aspect, and then I would deal with the commercial aspect. So mine is sort of tangential to my practice, but I thought it's worth speaking out because I think it is something that's very unique to Australia. And I say that as someone who hasn't surveyed every other country in the world and how they deal with this sort of issue. But I think the way in which Australia has dealt with it is perhaps unique in that context. Whether it's the right way or the wrong way, it's something that's been done. And I think it's unique and it might be interesting for civil law practitioners. So as I'd already sort of said at the start, Australia was settled on the basis of what is essentially a legal fiction, this idea of terra nullius. And in the 1980s, it became sort of pretty apparent, both politically but also legally, that you just couldn't maintain this fiction. It was just wrong and was essentially the foundation of our legal system, or the way in which the common law had arisen in Australia. Essentially, in the 1980s, there was a series of cases, but it started with a case called the Mabo case. And in that case, I'll just get it up, otherwise I will butcher it. But in that case, essentially the High Court recognised that prior to British settlement, Indigenous people actually had quite complex legal systems and quite complex relationships with one another. And they also enjoyed particular sets of rights to particular areas of land. And that was respected through particular laws and customs. And it wasn't understood at the time, or it was understood and wasn't considered important or ignored. But it's now sort of known today that these systems of law were actually incredibly complex and no less complex than the systems we had. But just obviously very, very different and very difficult for the sort of colonial mind to comprehend at that period of time. But the effect of these decisions from the 1980s onwards is that the courts found that certain rights of Indigenous populations in respect of land survived colonization, and in certain circumstances they were embodied in they became embodied in the common law, and now they're recognised and protected in Australian law, both by case law but also by legislation that's been brought in subsequently. What is native title? That in itself is a bit of is a complex question, but and it can mean many different things to many people. But in short, it's a bundle of rights, normally in respect of land, and these are they call like title as you would normally think of title. I own the title to land. Native title is a sort of adjunct principle that you might have some form of title to land, and they call it native title, and something that sits outside of that. Basically, at one level, it can include these sort of general rights about rights to camp, hunt, use water, fish, perform certain ceremonies and these sorts of things, and also to protect particular cultural sites of significance. So particular structures and rocks and trees and things that are very important to particular Indigenous people in particular areas. There can also be a right to preserve those areas. And where those things often clash is, for example, where you have, a mining company, and where I've seen a clash is where you have a mining company that purchased some bit of land in the 1940s, and they got all this, they got huge, bits of land in the middle of Australia, and they say, well, this is my land, I paid for it, I have indefeasibility, my title beats everybody else, and I have exclusive possession, I can sort of do whatever I want with it, it's my land. And then there's this subsequent concept sort of originating in the 1980s that, well, perhaps actually there's this sort of these people that used to be here actually have some remaining rights that they should be able to exercise in respect of the land. And so for an English lawyer, and I think I said this at the start, property rights in the common law system are king. There's no better form of rights than property rights. It's they're strong and they've been built up over hundreds of years. And so we have this idea of what property rights are. And, when you tend to buy a house, if you lived outside Australia, you might think, well, I bought this house and this bit of land, it's my land, and no one can take it from me and no one can come onto it, and I can tell people to go away. And then there's a question about, well, what does that mean in Australian context, in circumstances where we need to recognize that, in fact, there was a sort of original fiction upon which all this is based, but we've gone sort of too far to sort of, reverse the whole thing. Can we sort of back end it and recognize these rights to some degree within our ordinary Anglo conception of property rights? So these native title rights can, in certain circumstances, or the part that's probably most interesting is where they coexist with ordinary proprietary rights. So in certain types of cases and in respect to certain kinds of land, like pastoral leases, for example, certain Indigenous people can come onto land and do certain acts like camp and perform ceremonies and things like this, and maybe preclude them from being able to demolish a particular site or something which has some sort of significance, sort of cultural significance. It can involve other kinds of rights, like commercial rights, and there's rights to use particular areas of land and for commercial purposes. And there's always this argument about what the scope of those rights look like, because sometimes the extension of those particular rights involve a reduction of other kinds of rights, or the lessening of other kinds of Anglo, traditional Anglo property rights. So you get this point where there's this sort of, it's a very hot topic, and it's something which the courts are commonly grappling with, and part of it's regulated by legislation and part of it's regulated by the case law. But the part that I think is interesting, and the bit that I sort of wanted to point out, is a very, very intricate and in-depth area, not something which you can sort of explain in this, sort of 15, 20 minutes that we've got. But the bit that I thought was interesting is that I'm not sure of any other countries, at least that I've seen. Obviously in America and in Canada, and there's other countries I'm aware of that have particular ways of trying to recognize, past wrongs that have been committed, and in similar sort of scenarios. But I'm not sure that any of them have dealt with it in this particular way. And, it would not shock, but I think, if you had no idea and you were an English lawyer and you have a particular conception, sitting in England, sitting in London, thinking about what property rights are, and then you ask an Australian lawyer, "Oh, your property rights like our property rights?" We'd say, "Oh, yeah, they are. Oh, actually, but we've got this native title thing too, and it sort of works like this." And when you start to explain it, you realize, oh, actually, it was probably entering a different conception of property rights, one that sort of looks a lot like what was supplanted from England, but which has a sort of change. And, the scope of these things has always been debated. Like, there's cases galore, and there's whole practice areas devoted to native title, where some barristers, it's all they do. They only do native title. It's a sort of very unique space. And if you're not, so you can't dabble in it, and I don't dabble in it. But if you sort of are committed and you do it, then it's a space you can make your entire practice about it, because there's an awful lot of cases. And obviously each case, has the scope extends or reduces or changes, or the core solidifies, or however it is. So that's one particular area I think I just thought was something which I thought was unique about Australian law, and I thought that civil lawyers might find that interesting. That's all I proposed to talk about, really. Coming on to top. Happy to take any questions.
Wonderful. Thank you so much. Yeah, indeed. Are there any? There we go. I have noticed that there is a wig in your backgrounds. Are Australian lawyers and judges required to wear wigs in court?
Yeah, there is. So it's like show and tell.
Yeah, exactly. Cool.
Each one is individual. I don't know if it's similar. Do you wear them in civil law jurisdiction? No. Each one is individual. This one is a Australian horsehair. You might have told from my sort of might have been able to tell from my sort of lecture on divergence that I'm probably a stark Republican, and I think I appreciate the English tradition, of course, but and I have a British passport, but I think of myself as uniquely Australian, and so I have a Australian horsehair wig. As to when do you wear it, and there's all sorts of rules about that too. But in trial, primarily in trials and cross-examining witnesses, you wear it. You don't wear it in the federal courts, so you only wear it in the state courts. But we are otherwise gowned, and I think civil lawyers wear gowns, don't you?
In some countries, yeah.
Yeah. So we wear gowns and wigs, which makes us really fit in when we're walking down the street to the court. But I think the original idea is that it would provide, I mean, the original tradition, which started many hundreds of years ago, was that it would provide you with some level of anonymity because you all look the same. And so when you cross-examine someone and they're mean with you, they wouldn't know which barrister to exact revenge on, because you would all be wearing sort of these horsehair wigs and gowns and all look very similar. I tend to, obviously in arbitrations, we don't wear them, we just wear suits. But in the state courts, we always wear gowns and wigs, except in the Court of Appeal, where you just wear gowns, but no wigs. It's all sort of regulated by tradition, in a sense. It's very odd. And then you have to wear your wig if the judge wears the wig, but if the judge takes the wig off, then you have to take your wig off. So it gets even weirder. But when you say these things out loud, it sounds really weird. But then when you're doing them on a daily basis, you forget that they're very odd. But yes, we do wear wigs to court most of the time.
Are they all the same? Do they all have to look the same? They're all made out of horsehair to begin with, or?
Well, you can get vegan ones now, so they make them out of a sort of synthetic. But there's basically only two makers of wigs in the. Oh, I think there's 3 makers of wigs in the world or something like that. The oldest one is Eads, which is the English one on Savile Row, and they have used English horses, and they're very, very white, so incredibly white. So those are probably the ones you see in the movies and English movies. And then the Australian ones have a more of a brindle, because the Australian horses are browner and not as white. So you have to choose your you have to choose which side you're on. But a lot of people over here, of course, because there's a strong contingent of English lawyers and English barristers. A lot of barristers in Australia practice in England. A lot of English barristers practice here in Australia and have that dual recognition, because we've done extra courses and things. And so you see a lot of very white wigs, and they're either English or trying to be English, or you wear your sort of brindle wig proudly.
Cool.
Which is next.
Thank you. New question on the chat. Could you please elaborate a bit more on the Australia-New Zealand differences with regard to the status of Indigenous rights?
Yeah, so I just by way of background, it might be interesting. So I'm British, Australian, and I was born in New Zealand, so I have a New Zealand passport as well. So that's why I know a little bit about all of it. But I think of myself as really Australian, unless I'm sort of Australia's losing the rugby or something to New Zealand. What's the difference? Well, the difference stems from the way in which British rule came to be. So in Australia, we were talking about this concept of terra nullius and the idea that the legal fiction that nobody was here. And so you could just apply English law as a blank slate. They tried that in New Zealand, but it didn't go so well for them, because the Maoris are a warrior population and known for their fierce sort of warrior tactics. I think there's a lot of conflicts, and then ultimately they came to an agreement. And there's an agreement called the Treaty of Waitangi. It is written side by side in English and sort of, I think, what was the predominant Maori language at the time, essentially because it was ceding. And there's all sorts of problems with that document too, because, the first time they sort of meet New Zealanders is when they're sort of trying to colonize New Zealand, and then you have translation issues. And currently in New Zealand at the moment, there's sort of revolutions galore where people are in fierce opposition to each other, because people are trying to reinterpret what these things mean, and they now think they have better understanding of what the Maori language was at the time. And so you have the English version of, oh, you will cede to, you know, Britain and you'll be ruled by Britain, etc. And then the Maori version says sort of, well, yep, we'll cede to Britain and you can tell us what to do, but we're not going to do it if we don't want to do it. And like, and then it's in a different language. And so there's all sorts of differences between the two languages. And, you know, they obviously came to an agreement and they've sort of been living quite well, but ultimately what happened was you have a far greater recognition of Indigenous rights in New Zealand than you do in here. And so it wasn't until the 1980s that you had that here, but from the very beginning of when New Zealand was essentially ceded to the British Empire, you had a recognition immediately of Maori rights. And, you know, I'm not sure, you know, either side was particularly happy with the bargain that they got, but that's the bargain that they struck. And now there's questions about how that filters in. But, you know, there's questions, I think they have sort of huge, if you look at the two demographics in Australia, very small Indigenous population in Australia in sort of certain fields, like in Parliament, there's sort of 1 or 2 Indigenous people in Parliament. Whereas if you look in New Zealand, you know, you've got huge portions of their Parliament which are made up of Maori people, and they have a much greater voice. And it's more difficult. They get more out of their rights, and it's more difficult to destroy their rights and things like that. So I think from the very beginning, they got a greater recognition, and then that's sort of solidified over time. But there is currently a debate about, you know, the original reinterpretation of the Treaty of Waitangi and whether that is its own legal fiction as well, and how that plays in sort of current New Zealand politics and law as well. So,
all right. Wonderful. I think that's it. We are coming to the end of the allocated time anyway. So thank you so much, Jason. Jason is taking time out of his evening. It's now 8 p.m. In Australia. Thank you so much for having been with us today. This was super interesting, and many things I had not covered in classroom, or many things you built on. So I think this was, from my perspective, super useful, and super really interesting to see how this works behind the scenes, so to speak, behind what is happening on the page, what you can read about Australian law and New Zealand law. So thank you so much for that. It was really great. And yeah.
And if any of you are ever in Australia, feel free to pop in and say hey. And if you have any questions, of course, Thomas can share my email with people, and feel free to send me questions if you have any, or if you want to chat.
Okay. Awesome. Thank you again. Have a good evening, and hope to see you soon. Bye-bye. Bye-bye, Jason. Bye-bye. Thank you.